held dear as well. And so we're delighted to have him this year. Many of you may know that Professor Forman has been leading a series of panel events. This is the third and final panel event that have been based on or inspired by his co-edited anthology, Dismantling Mass Incarceration, A Handbook for Change. And so if you don't have a copy of the book, there are copies out front. Make sure you grab one. If you missed the previous events, which were on the role of public defenders and beyond incarceration, they are on our YouTube channel. So please make sure to go and check them out. Tonight, as I said, this is the last event in what has been a really incredible panel series. And tonight we'll be focusing on rolling back New York's excessive sentencing. There are currently 30,000 people serving time in New York State prisons, with a significant portion of those folks serving long-term and life sentences. In New York, we are looking at passing the Second Looked Act, which is in front of the New York State Legislature and aims to address this issue by providing a mechanism for folks to get resentenced and find relief from those long excessive sentences. So tonight on our panel, we are very fortunate to be joined by a number of folks who are really thinking deeply about this issue. We have the Honorable Frederick Block, who is a senior federal judge of the United States District Court for the Eastern District of New York. We have Thomas Gant, who is an advocacy and community organizer with the Center for Community Alternatives. We have Mujahideen Muhammad, who's the founder of the Pillars of Promise. David Singleton, who is an associate professor at the University of District of Columbia, David A. Clarke School of Law. Jennifer Soble, executive director of the Illinois Prison Project, and our very own Steve Zeidman, who is professor and co-director of the Defenders Clinic and the Second Look Project here in the law school. So before I turn the panel over, I just want to make sure I say thank you to all the people who have made this evening possible. Thank you to Dean Setti, to the CUNY School of Law Foundation, our friends in the New York State Legislature, who are really behind everything that we're able to do with this program. We also want to thank the CUNY Law community members who contributed so generously to establish this chair back in 1998. For our student organizations, we have the Abolitionist Law Organization, the Black Law Students Association, woohoo, give it up, Books Not Bars, the Formerly Incarcerated Law Students Advocacy Association, and HALT Solitary Campaign. Thank you to all of our student organizations and to the students who have come out to support the event. And the very last thing I say before I'll pass it over, because this is a lot of people on the panel, we got a lot to talk about this evening, is that we will have a reception after this. There will be food, there will be wine, so we hope that you stay. And there will also be an opportunity to have your book signed by Professor Forman and by Judge Block, so please stick around for that. There's also materials from the Communities Not Cages campaign. If you haven't, they're in front of you. If you haven't taken a look, make sure you take a look. There are more materials outside. You'll hear more in a moment. And please stick around and engage with us as we talk about this important topic. That's enough for me. Thank you. Turn it over to you, James.
So thank you all for coming out. And I just want to add one more thank you, which is to Nicole. Because so I don't know how many people in the room are professors. If you're a professor or faculty member at any university, could you raise your hand? Okay, so one of the things you know about professors is that they get these things called leaves or research leaves or sabbaticals. And Nicole is on one right now. And most people, when they're on leave, you do not see them around at the school. You definitely do not see them organizing community events like this one. So we just have Nicole to thank for putting this series together and for your energy and for your passion and for your love. So I want to get, I think you know about who the panelists are. You have bios that were handed out. But I also think it's important to get a sense of who's in the room. So what I'd like to do is, if you are a student, whether you're at CUNY Law or a student at some other school, could you raise your hand? Okay. Thank y'all for coming out. Thank you for coming out. If you are faculty or staff at CUNY or another university, raise your hand. Okay, thank y'all. Thank y'all. If you are members of the New York community, you're not associated with CUNY or another university, but you're a member of the New York community, you heard about this event, please raise your hand. Thank you. Thank you. Now, I've another question. And that is, you heard Nicole say, you're going to hear a lot more about this problem of excessive sentencing. I just want everybody right now who is currently, right as we sit here at 6:25, the panel has not yet begun, but who is currently aware of the problem of excessive sentencing in the United States and in New York. If you are aware of that problem as a problem, please raise your hand. Okay, so everyone's aware of it. Okay, now they're going to get some depth and some nuance and some proposed solutions and responses tonight. If you currently would consider yourself doing something to respond to that problem, please raise your hand. Okay, I would say most of the room, a little more than half maybe. So what I want to say is if you didn't raise your hand to that last question, right, you're not doing anything right now, that's fine. That's why we're here. If you did not raise your hand, it's no judgment. But my hope and my prediction and my call is that by the end of the night, everybody will raise their hand to the question in response to the question of, am I doing something? Because those of you that didn't raise your hand, you're going to be raising your hand because you plan to do something, because you've heard an idea here that is going to inspire you to do something. And if you already raise your hand, then you're going to have some more ideas of things you could do or things that you could tell a friend that they could do. That's my hope and that's my charge for the event tonight. So we're going to talk for about an hour panel. Then we're going to have about 15, 20 minutes for conversation from the audience. So everyone has a mic, so be thinking about your questions. And then at about 7:45, roughly, we are going to retire outside for drinks and food and continued conversation around these issues. That's the framework. So this is a talented panel. It is also a big panel. And so what I told all the panelists, and I just want to share with you all, I told everybody that we're going to keep this conversational. We're going to keep this quick. It's not going to be speeches. And if I have to interrupt anybody, it's nothing personal at all. We're just trying to keep the flow moving.
It's pretty hard for a judge to do, by the way.
I'm worried about you, Judge Block, because I have been in front of a lot of judges. So I'm prepared, though. I'm prepared. I'm ready for you. So, Jenny, I would ask you to start us off. You come from a state that does not have second chance legislation. One of the things we're going to be talking about tonight is proposals in New York, which include a proposal to enact second chance legislation in this state. You come from a state, Illinois, that doesn't have it. And so I was just wondering if you could start us off by talking about what you see in Illinois and what that has taught you about why it is so important to have meaningful second chance laws.
Yeah, absolutely. Can you guys hear me? Great. Thank you so much for having me here. Just to start. So Illinois is ostensibly a very blue state. We like to call ourselves progressive. And yet we have a prison population that is as big as New York's, 30,000 people and climbing every year for the past 5 years. We also have 10% of the nation's population of folks serving actual or virtual life sentences. So sentences over 40 years all the way to virtual life. Our little state, 10% of those folks are in Illinois. We have, one would think, everything but second look resentencing. We have, since 2019, prosecutor-initiated resentencing, which I know is under consideration in New York. Before we had prosecutor-initiated sentencing, we had a common law doctrine that would let prosecutors get folks back into court for resentencing. So we've sort of functionally always had prosecutor-initiated resentencing. Since that official law passed in 2019, 5 people in the state of Illinois have been released through prosecutor-initiated resentencing. 5 people total. So that's not worked. Illinois also has a parole board. We have folks who are eligible for parole in 3 different ways. Some were convicted before 1978 when Illinois abolished parole the first time. And we still have about 40 people who have been in prison since, over 45 years at this point, who are still not being released. They will go before our parole board, and at this point, the grant rate is like 1%. That same parole board also considers cases of folks who were granted clemency by the governor to make them eligible for parole. That's the other way that folks get sort of fed into our parole system. And the last way is that Illinois has a juvenile parole bill, which lets folks who were sentenced after 2019 go before the parole board after either 10 or 20 years, sort of depending on what their underlying offense is. Since that law went into effect, a handful of folks have been released through our parole system. Our parole board is punitive, they're mean, they seem to try to make a point by denying folks. And what makes our parole bill so tragic is that if you are denied, and especially if you're convicted of murder, you don't get to come back for 10 years. So there was a hearing today. 2 juvenile parole cases, 3 cases were up total. 2 were juvenile parole. 1 was a person who was made eligible by our governor through our clemency process. 1 of those 3 people was released. The other person who was denied unanimously, the members ended the hearing by encouraging him to apply for clemency. Which, if anyone knows anything about clemency in Illinois, which we also have about, 20 or 30 people get granted in a year where our governor is granting them, which is not every year. The final thing that we have is medical release. It's a new bill passed in 2022. It is actually pretty effective, but it's pretty narrow, and it only applies to folks who are terminally ill or disabled. We have no process by which incarcerated folks get to go back before judges, which means we have no process that incarcerated folks can access on demand. We have no process that involves the right to counsel on demand, and we have no process for folks other than in these limited statutory schemes to get their sentence reviewed other than clemency. It's pretty dark.
Thank you. David, I want to bring you in from Ohio. I remember a number of years ago, so I've known David Singleton since we were public defenders in Washington, D.C. in the 90s. And I remember a couple of years ago, 5, 6, maybe even 10 years ago now, you called me and you said, a lot of people are working on innocence, and that's important. But I really want to start working on excessive sentences of people who are guilty. They're not contesting their conviction, but their sentences are just too long. And so I was wondering if you could talk about, Jenny's talked about Illinois, if you could talk about what you see in Ohio and what it's like to, from your perspective, to practice in a place which also doesn't have second look or second chance legislation.
Thank you, James. I don't want to start an Olympics competition in which state is worse in terms of second chances. But Ohio is just horrible. We lock up the 4th most number of people in the country. There's like 40,000 plus people locked up. Parole system, terrible. Medical release actually is not that good. I mean, it's pretty terrible for folks who are really sick. It's hard to get them out for that. And it is a broken system. And, when we started, I say we, I'm no longer in Ohio, but my old shop, we started this Beyond Guilt project to try and free people who are overpunished, who have no other way to get out. And, we got people out by begging and pleading prosecutors to bend the rules. Yeah, bend the rules. No, we're not entitled to file a motion for a new trial, but we're going to file one anyway, and the prosecutor's going to come to the judge with us and say, ignore that, let's let this person out. But the people we've gotten out is a drop in the bucket. Maybe 40, 50 people in the last handful of years, those 40 people are super happy and grateful, and their families are super happy and grateful that they were able to get released. But in a system that incarcerates 40,000 people, and I'm talking about people who've committed murders, the people who got out, they're not contesting that, but they've been in for decades. How long do we need to keep people locked up when they have changed, when they are no longer the person that they were all those years ago? I represent a client right now who's been in since 1976. She's 82 years old. She can barely walk into the interview room. When is enough enough? And so my prayer for Ohio is to get a second look law that will equalize opportunities for justice for oversentenced people across the state, because we've got a handful of relationships with prosecutors where we've been able to get people out, but that needs to be statewide. And it should not just be up to prosecutors to decide when enough is enough.
Thank you. Judge Block, I want to bring you in. So far we've heard from 2 states, and we're about to, after we talk to you, going to shift our focus to New York. But I would love to hear from your perspective, because you operate as a federal judge under federal law. You've had the First Step Act. And I think one thing that a lot of people don't really understand, but that you do, and you write about in your book, which is here and that a lot of you all have, and if you don't, please pick one up on the way out, is that there are severe limits to what can be done on this issue in the federal system. This is fundamentally a state, county, local question, which both has pitfalls and it also has promise and potential. And so I was wondering if you could talk about what you've seen under the First Step Act and why you think legislation at the state level is fundamentally the thing that needs to happen for there to be more significant change.
Well, James, it's good to be here. Can people hear me? I don't know whether this is working or not. So you may or may not know that the First Step Act has changed the sentencing landscape in the federal courts in the United States of America. And it's something which is not, I have expected to see that happen, but the Congress, both Republican, Democrat, conservative, liberals, they realized that we had to do something with our humongous mass incarceration problem. And it's to their collective credit. I hope the current Congress will take the second step, but who knows? But back in 2018, it happened. And it provided a vehicle for inmates to directly come to federal district court judges and ask for a reduction in their sentence and even to be released from incarceration. And we have been inundated with these applications over the last few years. And it motivated me to write this book. So we talked about a bunch of them that I had. The first one was Volpe. Remember Abdulwima?
Sure.
So Volpe petitioned me to be let out of jail after 21 years. He was sentenced to 30 years by Judge Nicholson. And we've had a bunch of these types of things. And I looked at that and I said, we have to sensitize people to understand what is going on here, because our mass incarceration problem is an embarrassment. We have 4% of the world's population and 20% of its prisoners. 4% of the world's population and 20% of its prisoners. It's a huge embarrassment. But the federal law is wonderful because it now gives inmates the opportunity to come to Judge Block and to come to my colleagues and to ask for a second chance. I'm not going to go through the structure of the law because we don't have time, and moderator is going to cut me down for sure. He can't wait to do that. But we've had 5,000 of these applications granted throughout the United States. And it's a dent, but it's a conceptually important thing, and it is happening. And I've done my share. and I feel pretty good about what I've been able to do. And I think that the federal bench is really, the leaders in what ought to be done by the states. So the book ends by talking about the states. And we talk about the parole system, James, and the prison policy initiative rated it. 36 states got an F minus. The others got an F or horrendous. It's broken. And we are trying now, and I'm trying to go throughout the country as best as I can to advocate that the states have to also step up because they have 90% of the incarcerated people. The federal government only has 200,000. So we're not going to be able to really get a dent in our mass incarceration problem unless the states are going to step up to the plate. The New York State, of course, is the object of our affection here. I spoke to Senator Salas's chief of staff a year ago, and I was so upset by what she told me because we have this proposed bipartisan legislation. It's been proposed for the last 3 years, and why has it not been enacted into law? Because the leadership is gun shy in New York State. The Bail Reform Act, they got a hit, that they're soft on crime, and this thing is politically sensitive stuff, and it hasn't happened. It has to happen. So you had the Second Look Act in New York State, and we talked about how important it is for New York State to enact that. So I can go on and on and on, but I just want to be focused, as difficult as it is for the judge to do that, to answer your question as succinctly as possible.
Thank you. You get an A+. I want to shift now to New York, and I appreciate Judge Block you leading us there. And so I really want to talk about New York in two parts. The first is I want to talk about a little bit about the problem of excessive sentencing in New York. What does that look like? Who are the people? What are the numbers? And so, Thomas, I want to turn to you because you've been doing advocacy, leading advocacy on this issue for a number of years now. So if you don't mind, just begin by outlining for people what is the problem of excessive sentencing in New York State right now.
Thank you for that. Thank you for saying that, Judge, and just everybody for being up here, sharing, and even in the fight to make change. New York State has a huge problem with its sentencing laws that's going on right now. I'm going to say it's the main driver to the reason why we have mass incarceration issues now. I can easily say it's draconian, racist. Those are easy, low hanging fruit that I could use. But wholly is doing harm to humans. There's a lot of people who sit in prison for decades, right? Who've shown redemption, who've shown change, who've shown remorse, and they sit. Because of New York State's stance on tough on crime, we can go all the way back to the 1970s, Rockefeller drug laws, all these other different things carried on. And the problem is it's not up to date. I'm going to say it's even archaic. The problem is society wants different. You asked the question in the beginning of everybody who says, do they know or feel as though there's excessive sentencing problems in New York? Everybody's hand went up. Yeah. So the problem with our court systems, our Department of Corrections, sentencing law structures is that it's not caught up to society. Society feels differently about certain things that we probably didn't feel the same way years ago. Years ago, we didn't have science data who says that a person who committed a crime under the age of 25 probably couldn't necessarily help it because their brain wasn't fully developed. We didn't have this stance on domestic violence and people who have been harmed by that. We didn't take into account mental health issues, or even addiction. So the problem with New York sentencing laws is that it's not caught up to what society is saying. I was so thankful to hear the judge say that New York State is just gun shy. They want to stay away from sort of political hot topics, but it's unfair because they're doing harm to humans.
I'm going to take a risk of being held in contempt of court by a
I would never hold you in contempt, Judge.
We have people here who are motivated to try to make changes.
Yeah.
And the school has a rich reputation of people who really care. And we have a bill ready to be executed, and the governor won't do it. And the leaders of the legislature, for whatever political concerns they have, won't do it. There's major efforts being made to get them to sign the damn bill. How do they do it? You gotta really be active, you gotta reach out to your legislators. You have to say, this is not acceptable, you've got to pass this bill. I mean, I'm sort of focused on getting things accomplished, but that, I think, is what these folks have to do out here. Am I off base or not?
No, in fact, you're trying to take my job. That's my job, Judge. Trying to get the information and get our citizens to say that and to be active. So we are doing several things. We actually passed out some information. I'm going to talk a little bit later, but I'm trying to stay on topic. I have a conversation with Mr. Forman about staying on key, but we have the remedy for that, right? And we are poised in 2025 to get some push, to get some legislation passed, hopefully. But it takes moments like this. It takes people like you. I would love to bring you to Albany with me. Just sit with, they need to hear this, right? And that's the problem that I'm learning as a community organizer is that lawmakers need to hear that. They need to have your emails, your phone calls, the aesthetics. You need to show up to our rallies. You need to come to Albany with us and sit down and talk with them and share with them on what it is that you want. And I want to say this, Judge, before I pass it, that the harm is being done not to those that's incarcerated, but also families, loved ones, mothers, sisters, children that's left behind. I took a phone call this morning, and I have to share this. It's just that the harm and hurt that's being done to keeping families from being made whole again, right? That's what make our communities safer. That's what's going to make us thrive in our communities when we can make our families whole again by releasing people who sit in prison for 20, 30 years unwarranted. I was in prison for 25 years. Went to prison at the age of 21 and got out at the age of 46 a little over 2 years ago. And I had done everything I could in prison to become a better person. But because of the way the sentencing structure is now, sentencing laws is right now, nothing I can do but sit there. And I'll say this, Judge, if there was a mechanism in place where a judge can look at certain issues that cause them to find themselves in that situation, they would want to do something as well.
We've done it on the federal level, and you know
All
what?
right, Judge,
Pass it.
I told you in advance that this might happen. So I'm going to interrupt you now because there's some other people I want to bring into the conversation. But I will come back to you.
I need to take them to Albany with me, though.
Please do. I want you to do that. So Mujahideen and Steve, I want to bring y'all into the conversation, and I want now to talk about exactly this back and forth that you were having, Thomas and Your Honor, which is there is a proposal right now that is live in New York for legislation that would be really groundbreaking in terms of providing second chance and second look opportunities. And so I would love for Mujahideen, if you go first and then Steve next, just to talk a little bit about what is that proposal? What does it look like? What would the law be that is now under discussion?
Thank you, James Forman. First, I would like to thank CUNY Law and everyone that's been a part of this event for inviting me. I'm truly honored to speak on behalf of the many men and women who have these excessive sentences and are hard pressed to gain relief because of our lack of the failures of our system, systems on the back end. The bill that's being proposed and being supported by a significant number of people in Congress is Senate Bill 321, Assembly Bill 531, and it would allow incarcerated individuals who have lengthy sentences to apply to a judge for a sentence reduction after 10 years of incarceration or half their sentences if they have 10 years. One of the hallmarks of second look legislation that's being proposed and supported by a significant number of people in Congress is that there is a rebuttable presumption that an applicant's sentence will be reduced if the applicant was 55 years old at the time of submitting the application or under the age of 25 at the time of the crime's commission. And those two factors of rebuttal presumption, they serve a purpose. For individuals who are over the age of 55, New York State docs considers individuals who are 55 plus years old as elderly. And further, the the life expectancy for individuals who are incarcerated in New York State is 58 years old. And this is further bolstered by the sound theory that individuals age out of crime. In fact, studies show that as you move from one age group to the next, the rate of recidivism drastically declines. And that people who are 55 and plus years old, in a lot of cases, in a relative in health decline, that they are they essentially pose no threat to society. And that's the reason why this bill offers a rebuttable presumption that an applicant who is 55 plus years old, that he should receive a sentence reduction unless there are other factors that outweigh that. The other rebuttable presumption is that individuals who are under the age of 25, that they also be granted a sentence reduction. And that's because of the latest neurological science which the Supreme Court has validated in the 2012 Miller versus Alabama decision, where they stated that, where they recognized what neuroscientists have been saying for years, that the brain is still developing up into the age of 25, and that one of the hallmarks of immaturity is that people don't understand the consequences of their actions. Young youth don't understand the consequences of their actions. They're more influenced by peer pressure, and also when you couple that with adverse childhood experiences and environmental risk factors, along with their immature neurological development, that should reduce their culpability. And Supreme Court in 2012, Miller versus Alabama decision, they acknowledged that. But unfortunately, the relief that neuroscience ideology has been restricted to juveniles who are under 18, but the actual science, it says that the brain is actually maturing up to the age of 25. So a lot of advocates are trying to get legislators to recognize, that the other cohort. And in this New York State bill, it would recognize those who did crimes under the age of 25, and it would give a rebuttable presumption that they should have their sentences reduced, provided that there are not other factors that outweigh that.
Steve, I was hoping you could come in and talk a little bit about the origins of the New York law, and because I know you've been involved from the very beginning in trying to craft it, and talk and build on what Mujahideen said in terms of how it would work, who would it affect? How many people are we talking about who would potentially be eligible for second look, and why it's so important?
Yeah, thanks. And I have to say, this is just, I'm so glad to be here. These are friends, colleagues, and co-conspirators, so I'm glad to be here. And in many ways, I know we're preaching to the choir.
Can you check and make sure your mic is on?
Can you hear me in the back? It's on. Green light?
Here you go.
Thank you. Yeah. So I realize in many ways we are preaching to the choir, but let me just mention, James, I want to come at your question in two different ways real fast.
Okay.
One is I want to sort of recast the legislative piece. And because in my efforts speaking to legislators who don't fully grasp the ins and outs of the bill, this is one way I hope we all can think about it. New York State, you've created this anomaly. So when someone is arrested, and I know there are a lot of lawyers out here who know this, regardless what you're charged with, you can go into court and say, dismiss the charges in the interest of justice. And then in fact, if you are convicted, sentenced to prison, massive terms, your direct appeal, as some of my appellate lawyers in the audience know, you can ask the court to reduce your sentence in the interest of justice. And then now let's fast forward 10, 20, 30 years. We actually have a bill. We have a law that says you can move for resentencing. But you know the problem? It's only if your sentence was illegal. So in other words, it doesn't matter what you've done, what you've achieved, how you've changed, whose support you have. There's no opportunity to get in front of a judge. So for me, I'm just trying to reduce it to its essence. This is the conversations that I've had with legislators, their chief of staff. It's just, can we just insert the words interest of justice? That's all. Just let people come in to show who they are. And I just want to mention two other things. People here have talked about the morality of this.
Steve, can I just ask this question? So you're saying the idea is you would be able to challenge your sentence in the interest of justice. You get to go back and say, Your Honor, I deserve to be resentenced in the interest of justice.
Correct. And I think we have that standard along the way in New York. We already have it.
Okay.
And I think if we all sat down and said, what might be the factors for judges to consider, we could come up with them. Because basically, is it the right thing to do? And speaking, so I think, it is this moral imperative, but let me just mention two other rationales that I think it's clear we have support in this room. But as we're going to the legislators, let me just mention two other things. Different sort of rationales for this. To me, we can't predict the future. And this is, I guess I call this present company accepted. This is my problem with judicial hubris and prosecutor hubris. I must have read 500 sentencing transcripts where judges and prosecutors say, you will forever be a menace. You will forever be a threat. You should never see the light of day. And then you work with someone. I just want to shout out one of my first clients, a woman named Judy Clarke. She knows I say this all the time. Yes, indeed. Very high profile, very serious case. And at the time of sentencing, the judge said, I'm getting all these letters urging me to be lenient. But you know what? The way you've behaved in court, the nature of your crime, you will forever be a menace. I'm giving you 75 to life. And what do we know with the passage of time? This is why I hold up Judy. How wrong that judge was. Because 25 years in, there was so much support pouring in. The superintendent, people inside, outside, everywhere. The list of achievements was off the charts. Where was the opportunity to show that to anybody? So to me, a sentence once imposed, even if at the time a judge thought it was appropriate, does not remain just, necessary, and appropriate in perpetuity. That's the biggest problem. It isn't set in stone. And if I can, one last part of this, I also think for all of us as advocates, we have to move away from this notion that a resentencing or reevaluation is an act of mercy or benevolence. It has to be recast as an obligation, a correction, a need to rectify. And I think we've moved the dial a bit. And in so many ways, Thomas alluded to this. We know that, the profound racial disparities, which increase as sentences increase, are off the charts. So we can talk in a law school about why do we punish, incapacitation, deterrence, all that. At the end of the day, and I think it's important, and I know it's understood, we're punishing people because it's a method to control and subjugate marginalized communities. So to me, this is about rectification. I'll give you just some numbers, and then I'll stop. We work with a lot of people who were convicted when they were very young. So recently, I got some FOIL data from New York State. I wanted to know how many people were serving life sentences in New York for crimes committed when they were teenagers. And the number came back 841. It's a large number, but it's worse than that. Because then, just taking a deeper cut, according to the census, 17% of the people in New York State are identified as Black or African American. New York State Prison, DOCS, the Department of Corrections, says 50% of the people in New York State Prison are identified as Black. Those teenagers serving life, 2/3 of them were, to me, the racist trope of the super predator. It's alive and well. So it's a matter of this bill. To me, we can talk about the logistics of it. It's a moral imperative.
Thank you. David, I wanna bring you back into the conversation because if I understand this correctly, and Steve or one of you all will correct me if I get this wrong, but as I understand it, Washington, D.C. currently has, of all of the states, and think of D.C. as a state in this regard because this was legislation passed by the D.C. legislature. Washington, D.C. has the most justice forward second chance or second look legislation currently that is in law. And the New York legislation that Steve and others are describing would go beyond the DC law. But before we go beyond, let's just talk about what we have now in Washington, D.C., where you live. Talk a little bit about what the second chance, second look legislation looks like in DC. Just a little bit about kind of how it operates and who has been affected. Because I think, based on what you said, more people in the little small city of Washington, D.C. have gotten the benefit of second chance legislation than in all of Ohio and Illinois, under the outmoded laws you all are operating with in those states. So could you talk about what's going on in DC?
Yeah, sure. So there's something called the Incarceration Reduction Amendment Act that passed about half a dozen years ago, that in its initial form granted second chances and allowed people who were incarcerated to ask the court. It wasn't just the prosecutor doing it out of the goodness of their heart, but allowed incarcerated individuals who were under 18 at the time that they committed their offense and had served 15 years of their sentence to ask the court to release them. And that initial stage of the law was very effective. I'm forgetting exactly how many people got out before it was amended, but let's say it was way more than in Ohio, and also in.
Clarifications, the first iteration, we had a 20-year minimum. The second iteration was 15 years.
Okay, thank you. And then the second, it's called the Second Act Amendment. Now is not limited to folks who were 18 or under 18 when they committed their offenses. It now is for folks who were under 25 and under when they committed their offenses. Now, as good as that is, it doesn't go far enough, because people still are, who commit crimes when they are 26, when they are 30, are human beings. And at a certain point, I don't care if you're 30, 40 when you commit a crime. At a certain point, that sentence is no longer necessary for incapacitation purposes, for retribution, for rehabilitation if the person's being rehabilitated already, or deterrence. And so I think what is on the horizon here in New York, hopefully it will get across the finish line, can be impetus for DC to even go further than it has gone. And DC's got a good law now. It's good, but it's not enough.
Can I add something to it?
Yes, please.
They did try to expand the provisions. They try to put a they try to make the qualifications unrestricted with regard to age at the time of offense. They try to broaden it, but then the United States government came in Congress and they just stopped it. So they did try to expand the provisions, not just for people under the age of 25, but at any age. But the United States Congress stepped in. Even Joe Biden supported it, and he didn't allow it. So they try to do the most.
Oh yeah, they tried.
Yeah.
And Thomas, just could you clarify this, because I think I understand this, but I want to make sure the audience does, and also that I'm correct. So David said that in DC, you had to be under 25 at the time that the offense was committed to be eligible under that legislation. And am I right that the proposed New York law has no age limit? It is what David's saying DC should have. And indeed, Mujahideen, just as you said, and DC tried to do before Congress intervened. So it's regardless of the age, that's not a trigger. There might be presumptions that are triggered based on age, but anyone of any age, is that right?
Yes, sir. And so that was great that they had mentioned earlier. So obviously, we want to help our elders that's languishing and suffering in prison. We also want to help our young folks who committed crimes under the age of 25. But technically, our law and bill that we have, in place is for everybody, right? Any citizen of New York State who have been sentenced to this excessive sentencing will have opportunity.
So now I want to ask this question. And Mujahideen, I'll start with you, but I really want to open it up to anyone on the panel to respond to. So when somebody said, I think it might have been Steve who said, well, where, the folks in this room are on our side, right? The people in this room, for the most part, I think, I didn't ask this question specifically. I asked whether you were aware of the problem of excessive sentencing. But I think that it's probably fair to say that most of the people in this room are aware of it and think it is a real problem. Now, not everybody in the state agrees. And if we're going to win, we're going to have to both educate people about the problem, right? But also be prepared to respond to the counter arguments that'll come in response from folks who are skeptical. And they'll take various forms. But based on my experience, one of the main things that I hear from people when I talk about really any form of sentencing reform, but certainly second look legislation of this kind, second chance legislation, is people say, well, y'all are talking about crimes of violence. DC law, for example, the way it's written, basically I think everyone who has gotten relief under the DC legislation was convicted of homicide. So that's one of the things, from my standpoint, that I think is admirable about the law is it's not a law that was written. It has its flaws, but it wasn't a law that was written that says, well, you are going to be eligible for this if it's a nonviolent offense, if it's theft or drug possession, but if it's a violent offense, you're not eligible. So, and in New York, as I understand how the law is written, lots of people, not everybody, but a lot of people who would be eligible would have committed acts of violence. And so the question that I have, because this is what I hear in response, is people say, look, you committed an act of violence. And if it was a homicide, right, the most serious act that we have, if it was a homicide, people say, well, that person, the victim doesn't get a second chance. So why should you? And even if it wasn't a homicide, people say, well, the victim has to live with this for the rest of their life. And I want to understand what we say, what we should be saying in response to that argument. Because I think, A, it's a real argument, and B, in a room of people that are sympathetic, this is, if you could say, this is like a safe space. So let's figure out in a safe space what the best arguments are. Let's test them, and so that then when we go into less safe spaces, we are well prepared. So that's the question, is what do we say in response to that? And I see you've got your hand up, which I'm glad about, because I thought you were going to want to jump in on this.
No, just to give people some background. I was sentenced to 25 years of life at the fresh age of 19, for a grievous crime. And I really believe that everyone who sincerely advocates for second looks for individuals who have done grievous crimes, they should be able to answer this question. And I agree with you, it's a legitimate concern. And my response is that the punitiveness of our system is based on maintaining an adversarial relationship between people that do harm and people that suffer harm. And this is so that the most punitive measures could be sought to address the harm, and that it can be maintained by law. But what a lot of people are discovering is that the most punitive outcomes don't foster healing in those who have suffered harm. I believe that we cannot mandate how a person should cope or grieve with of abuse, injury, or loss of a loved one due to another person's actions. But what our criminal legal system can do is provide more alternative processes that are restorative. Because when a harm is done, one of the first needs that arise is knowledge. Why has this happened to me or my loved one? And our criminal legal system is not designed so that people that's been harmed could get those answers. Often decades pass and people who have suffered harm have not, they still have those unresolved questions about, why they have been harmed. And so I believe that if we provide more restorative processes so that individuals can understand the life circumstances of the one that's harmed them, the environmental risk factors that may have contributed to their actions, and give them some knowledge of the transformation that individual might have undergone, then it makes it more likely that there will no longer be an adversarial relationship between the harmer and the one that's harmed, and then it makes it more likely that they can forgive the individual that's harmed them because they're able to contextualize their life. And once you're able to contextualize someone's life, that's a way of humanizing them. But the system, it keeps individuals that's been harmed in the dark. It extracts what they need to get the most punitive measures established, and then they just barely suffering in darkness, and they have no understanding or no knowledge of the one that's harmed them, how he or she might have transformed, and if those processes could be more readily available to people that suffer harm, then it heightens the chance that the people that's harmed them could be humanized in their eyes. So I think there's a flaw in our system that allows people that have been harmed to remain with the same feelings of resentment and grief that they had at the initial commission of the crime. So that after 30 years, when you're asking for an impact statement, they have no choice but to view that person in the same lens that they viewed them when the harm first occurred. So that's just something that our criminal legal system, we have to implement more restorative practices so we could break down, this binary between people that do harm and people that suffered harm. Because it shouldn't be a dichotomy between when you have, like, that's the main criticism that people have for people who advocate second look acts. They're saying that you're re-traumatizing the victims. And the flip side is that if you look at what's been going on in a lot of states, you will often find that the people who have benefited from second look acts, they are playing significant roles in their communities to the point that they are preventing future traumatization from happening. So there could be a lot done, to break down that dichotomy of between the people that's been harmed and the people who've done harm. I think our system could be better, because now there's data coming out now where people are saying they don't desire the most punitive means. They desire more preventive measures with regard to stopping crime. And our system could do a better job of breaking down that dichotomy. And that's happening on small levels, and there's a lot more room to grow in that.
Okay, and thank you for that. I know other people, I want to invite other people into this question because I know all of you have had to wrestle with it in your work. So Thomas, I see your hand. Judge Block, it seems like you're getting ready to, okay, I'll get everybody on there. No, don't. Well, that's not so bad. Thomas.
And I'll say mine really quick because I want to hear the powerfulness that everybody else is going to share. And so 2 things I'll just add. So I went to prison for second-degree murder. I was convicted of second-degree murder, 25 years to life. Actually took the life of a young man. And I'll say this, that people who find themselves convicted of violent crimes, oftentimes that wasn't the first time violence happened. So normally a lot of what we call perpetrators or people who committed the violent acts was yet survivors of violence themselves, number one. So I always bring that into the survivors space. Number two, the survivors should be heard. And I think my brother eloquently said they're not given seats at the table to be able to have their voices heard. And so this is why we continue to perpetuate this flaw that we have in the system. But I have learned in speaking to survivors, even the survivors in my own bad instance that only took 4 seconds to commit, that they received much more healing when they found out the person who I was now and the things that I had been doing. It wasn't just me being stuck in prison. That kind of can fuel their anger. But when they start learning about the things that I was contributing to my community, my environment, and things of that nature, this is when they had their hair. And I don't want to share this story because I want them to be able to have the power, was rightfully so. But one of the things that they told me in specific is that they received healing when they found out of the things that I was participating in. And that helped them even more than knowing that I went to prison for that long.
Or at the risk of whatever, I'm obviously here representing the federal system, and we really have a statute, which is a terrific First Step Act, and this is what the states have to do. So we don't have any limitations. We don't have any restrictions. Anybody can make an application for compassionate release on the federal level. So that should be clear to everybody. And interest of justice, I'm a big fan of that, you obviously know, right? We do have some really great things in place. The victims are allowed to make victim statements. So they are incorporated into the system. And there has to be a healing process. And there has to be a process where there's some interaction between those people who deserve a second chance. The concept of redemption. Many of these people, we have representatives here, are different people today. David is absolutely correct, and I experience this all the time. The bottom line, in terms of all of this, is really we don't open up the prison doors. I don't want anyone to walk away thinking that everybody who's in jail should get out of jail, because we don't do that. But we do recognize the federal system, the concept of rehabilitation. It's primary. And I see these people all the time who have literally changed their lives. You can say they got religion or whatever you want to say. They are different people today. The laws are different today. And they deserve to have, a judge has an obligation to have a second chance to really reconsider a previously imposed sentence. Laws change. There's a whole bunch of dynamics. The last one that I left out of jail, I sentenced to 5 lifetime terms of prison 27 years ago, and now he's a free person. We had a victim impact statement who said, let him out of jail. I believe this man has shown himself to be a different person. There was a process where he engaged with the victims. And I think that this is something that's important. It's an intangible. There's no law that can change people's minds. If I had a loved one of mine who was murdered, I would be so emotionally overwhelmed. I don't know whether I can make that rational decision that I would like to make. I'm not that type of human being, I don't think. We have laws that are harsh. We have a punitive system. We have an obviously mass incarceration system. And we don't really respect the fact that human beings have the capacity and do change seriously. Those people I give a second chance to. Those people the states have to give second chances to. We don't have that mechanism in place. And it's troublesome to me to see people like John Lennon, who you know about, who's in Sing Sing right now. He wrote the book review for my book. I didn't even know who he was, but I know about him now. He deserves, if he was a federal prisoner, he'd be out of jail. He deserves a second chance. We got to get the law passed. Look, we're here to be activists, all right? If people there, I know that there are a lot of people who support the law in New York State, and then there's some leaders who don't. Those people, they should get into their communities and put people against them and tell them that if you don't support this, you're not going to get reelected. Talk is cheap. Action is really what we need. And you people, I think, are geared to be able to do that. They should not get reelected. It's a handful of people who are holding up that law. Forget about all the philosophical stuff. Forget about the back and forth. We've got to get those people to do what ought to be done. So I can go on and on and on. You know that. Cut me off again.
I got David and Danny had their hand up, and Steve, and then it looked like Mujahideen, you want. So we'll see where the conversation goes. David?
Well, I started by saying how awful Ohio is. But let me tell you, the 21 years I spent there was a blessing because it taught me how to think differently about people I disagree with politically. And so when I got that question all the time from the prosecutors that I was trying to convince to free folks, from legislators who we were trying to convince to get a second look bill going. And when they asked me those questions about why was it right for somebody who committed a murder to get out, my response to them was, come to prison with me, come with me, and sit down with me across the table from a human being that I am representing. Not everybody took me up on it, but some did. And the ones who did, and I'm not talking about, like, we don't have in Ohio progressive prosecutors. That doesn't exist. The prosecutors that we got to come to prison to meet with our clients were people who bragged. And I feel bad saying that I sat at the table with these folks. They bragged about executing people. But when they came into that interview room and sat down next to the human being that I represented, that is powerful. It's a shame that we have to show the humanity of human beings. That is just something we all possess. But it is so necessary to get some people to support second chances. So for those prosecutors and legislators, very, very conservative politically, I disagreed with them on almost every political issue. Those folks who made the trip, they got it and they were hooked. And that was important. And so the last thing I'm going to leave you with, and particularly the students, is when I was your age, I wrote people off based on their politics. I still want to write people off based on their politics. But we need to find ways to have conversations with people we disagree with so we can free more good brothers and sisters and human beings who are locked up. So,
Very good.
My answer really builds on what everyone else is saying here. So in Illinois, we are also working to pass a second look bill that looks a lot like New York's bill. And we have a couple of other pieces of really progressive legislation. And we often don't get anywhere until we bring with us either a member of our staff or one of our allies who was formerly incarcerated, who served a sentence for a very violent crime, who served a very lengthy sentence, and who was free because of something exceptional. Bringing up this, because your audience for this is the legislature, right? Like that's really who we're talking about. And when a legislator says, well, what about the victims? In my opinion, that's often just like a go away. Like it's just a way to end the conversation. They don't really want to talk to you. And it's a way to flatten the issue. And if someone goes to them who is directly impacted by this problem, who would be in prison right now, but for something extraordinary. So for example, we have 4 or 5 people on our staff right now who got clemency. Like there was no world. One of them was on death row. There is no world in which this wonderful human being would be free, but for some extraordinary act of grace from our governor, who really, did an amazing and just and appropriate thing. But he can say to a legislature, I killed a man when I was 19 years old, but I am so much more than that. And I've been so much more than that. And thank goodness I'm here before you today. And all we're asking for is an opportunity to expand that opportunity to review to the 30,000 people, at least in Illinois, 40,000 in New York. Because when you bring folks before decision makers, and this is, I think, exactly what David is saying, who are directly impacted by mass incarceration, who are serving excessive sentences, and who have literally no way out, just no reasonable, likely way out. When you bring those people directly to legislators, it's impossible to ignore not only their humanity, but just the immense waste of talent, of life, of love, that we are literally locking up. And so you go to them, we bring them, we bring directly impacted folks with us to Springfield every day that their session. Because you don't want to give them the opportunity to ignore the real harm. And because, as folks have said, this is harm that we're causing people right now. 2 cents.
Sure, I'll be fast. Well, because I second everything that's been said. I mean, for me, it's always summed up in the word proximity. Like, how do we somehow make that happen? But I'm thinking about less about the victims per se, but just the person who has been spared this kind of harm and just says, and I'm thinking of a very conservative Republican upstate member of the legislature who will get elected over and over and over. Who, when we had this conversation, he said to me, and I said this to some of my friends here, he said, I think if you took a life, you forfeited the right to ever walk free. That was the line. And same thing, how would you feel? And to me, I said, look, I don't pretend that I would have, how would I feel? I don't know. I like to believe I might feel a certain way, but, and this may sound, and it probably is too confrontational, and I didn't really mean it that way, but what came out of my mouth was, so are you really willing to foreclose the possibility of any redemption? Shouldn't we encourage, recognize, and value redemption? And I say this as not a particularly religious person, but I think all of us can say in our clemency applications, where we get unanimous support is from the faith-based community.
Mhm.
So it's always struck me as so odd that a lot of these folks who claim to be deeply religious and faith-based, you would think those, if anybody, would agree with redemption. So when I said that, are you foreclosing the possibility of redemption? It's not that I changed my mind, but I will say this, he had no response.
There you go.
Let me, I want to ask one more question, and we'll bring in the audience. But I'm curious to know how y'all think about this question of, it was a little bit raised by Judge Block's comment when he said, well, I'm not letting everybody out, I'm letting certain people out. And in the Dismantling Incarceration book that a number of you all have in front of you, in the chapter on courts, one of the pieces is an excerpt from a judicial opinion from Washington, D.C., where David was talking about. And it's a judge who's granting a resentencing to somebody who's convicted of a very homicide. And the judge is going down the list of all of the astonishing things that this person has done while they're in prison. And in this case, making a prediction about who they're going to be in the future, the opposite kind of prediction Steve, you were talking about, the asset that they're going to be to society. And one of the things that always troubles me about this conversation is the way in which we can suggest that the people that are eligible for a second chance are these extraordinary human beings. I mean, David, you said, come with me to prison, but one of the things that probably did not come across, I imagine, in that visit, but that you're aware of because of all of your years of working with your clients, and Thomas and Mujahideen, that you're aware of from your own lived experience, is how incredibly challenging it is to do anything extraordinary in an environment where educational opportunities are few and far between, where healthcare is denied routinely, where mental health care exists in name but not in reality, where you can get written up for anything, the whim of a guard or an officer. I mean, you have people that are going back for resentencing in DC 25 years and zero infractions, and I just don't even know how that's possible given how some guards give out tickets like candy. So what I'm trying to really wrestle with here and get y'all's reactions to is how do we hold both of these things in our mind at one time, that we both honor the extraordinary work that some of the people, including two gentlemen here on the stage and many others who have received second chances, and some of those who Judge Block has granted, and some of those like John Lennon who have been invoked. How do we honor that, but at the same time, not somehow suggest that that's a standard that you should have to meet? Because these kind of sentences, to me, they're an outrage regardless of how you live your life while you're in prison. Like 34, I can't, I want to live in a world where, and this is not far enough for some of my students, but I at least want to live in a world where you don't have any sentences that are, the maximum sentence that you could get is, I don't know what the number is, but let's say it's 15 or 20 years. And again, my students would criticize me for that. And that's okay. But you know what I'm getting at? So help to talk me through this. Mujahideen, I see you got, and Thomas, both got your hand up. So I'll let y'all start.
Talking about exceptionalism, that you want to make sure that Second Look Act doesn't cater to exceptional individuals. And
Thank you. That was a very nice. I'm gonna take that. Those are notes on how I can be a little bit more pithy and direct next time. Thank you.
be honest, I agree with you, and I kind of disagree.
Okay. Good.
I believe there should be a limit to the amount of time that people receive for, the worst of acts like murder. But at the same time, I do believe that individuals who are convicted for those great crimes and are guilty for those great crimes, that they have a burden of proof. They should as much as their circumstances allow, because we know there are institutions that don't cater to positive programming, and even though institutions like a Sing Sing, which you would think is inundated with positive programming, there's a lot of things that people don't know that goes on in Sing Sing that makes getting an education and having a positive mindset difficult. But I believe that when you do a grave crime like murder, it should be your responsibility to do as much as you can to remove that stain from your soul and to prove to people, how much you understand the gravity of what you did, the ripple effects of what you did, and you understand your whole life narrative. You understand what led up to the crime. You understand the instant offense. You understand what was your turning point. I think all of that should be mandated for people who does the worst of things, and individuals who do that to the utmost, mainly because their environment and institution that would allow them to take part in a lot of positive programming, they should be at the forefront of benefiting from the Second Look Act. And individuals who are in institutions where they don't have that, we definitely have to find ways we can recognize how much they have transformed. But anybody who I'm not gonna, as a religious person, murder is a grave thing, and people who are guilty of those crimes, they should receive, a fair penalty, and they should be charged with coming to grips with what they've done and being able to clearly demonstrate that they understand what they have done and the work that they put into rehabilitation. So it's kind of like a blend between the two. We're not for exceptionalism, but yet that doesn't mean that people who do these crimes don't have to put the work in. And real quick, I had about 11 guys who I communicate with a lot of guys that are incarcerated. I had about 11 guys, right? I had asked guys questions about how they feel about the Second Look Act. and how it could be improved. And one of the guys named Michael Hoffa, who's an exceptional individual, he listed out a range of things that a person should accomplish, if they were within his means, to make himself deserving of a second look. And that just shows that anyone who's done a grave crime like murder, they understand what their responsibility now is. They understand the debt they have to pay to society and how much they have to reform to become deserving of a second look. So we're not for exceptionalism, but we definitely, people who do the worst of things should have to put a level of work in so that people can recognize them for being a completely different person.
Thank you. I got Thomas, and then I'm gonna come to you. Go ahead.
I'll make mine real quick, Judge. So one of the things, I'm not going to agree everything that he said. I'll just underscore. One of the things that I've done when I was incarcerated is help start mentor youth programs and stuff like that. So one of the things that we wanted to make sure that people who was involved in that program, that we had just saying, simple, regret and remorse means nothing if your actions not in line. So our goal was to make sure that people actions spoke the change, the redemption that they were seeking. Obviously, selfishly people sought it, but your actions had to line up, number one. But I just want to look at it from a different perspective. I was a part of an exploratory committee when I was in Attica. And one of my brothers is in the audience in here. He remembers Superintendent James Conway. I can mention his name because he's retired. So Attica is known for its infamy, right? Not just a famous thing, but the infamy all over the world. People from all over the world want to know about what the heck is going on in Attica. Terrible place, by the way. Can't wait for them to knock it down. But so some people came from Norway, right, to talk to us and shit and want to figure out what is wrong with America, the way you guys look at incarceration. So besides the fact that their COs have an honor, like it's an honorable thing to be a correctional officer over in Norway. They have the 50-50 thing, 50% men, 50% women. You need to know how to interact with people. They make sure your family come and get involved with you. They make sure you go out in the community and work. Nobody over there can get more than 10 years for committing a crime, no matter what they did. But the fundamental thing that really stuck with me, and I keep saying this in all the spaces that I find myself in, is that they look at it as this. If you commit a crime in our society, they look at it as, how do we fail you? Mm-hmm. So did we prevent you from certain accesses or certain opportunities? Why did you commit a crime in our society? And so because you did, guess what we're going to do? We're going to make sure we raise your citizenship to make sure that when you leave here, after 10 years, if that's what you got in the max, you're going to be able to contribute meaningfully. So United States, greatest country in the world. I haven't been to any other country besides Canada, but we don't count that because I'm originally from Buffalo, so we go back and forth to Canada all the time. But I haven't been to a lot of countries, but one of the things that I can say is that the greatest country in the world, we got it wrong. We look at it as a person committed a crime. We want to be punitive. We want to, victims, survivors, you don't have nothing to say because we don't continue to punish you. We need to look at it and say, how do we fail you? Did we prevent you from certain opportunities, access to certain things, to be successful, to flourish, to thrive, right? So some of our policies definitely reflect that, right? This is why we're doing some of the remedies we do now with the bills that we got. But we have to look at it as, if you commit a crime in our society, how do we fail you? And when you look at it from that type of lens, you'll want to do some of the reform, the remedies, and provide access that's not happening in our country now.
Let me agree 100% with Thomas. I also mentioned Norway in the book, by the way. They have a whole different philosophy, and most of the European countries, I think Germany, they can't sentence anybody for more than 13 years. There are limits to that. We have, in supposedly a civilized country, the most horrendous, worst philosophy and concept, and the most punitive concept of penology. But you raised a very good question, because a lot of the problems we have are the prison system. And, in New York State, we're talking about New York State, we have the Rikers Island, we have the NDC, we have the MCC. They're horrendous. People don't have the opportunities that they ought to have to give them a chance to really turn their lives around if they don't have a conducive environment to do it. Yes, there's some good programs out there, but when we sentence somebody now, and when I consider, the First Step Act, I take into consideration the punitive aspects that a person has been subjected to in our failed prison system. And that is one of the factors I consider. I have a hard time letting people out who have been bad people in jail. It just troubles me to do that. I don't think they deserve a second chance. But yes, there are problems. I understand that, but there's no real ready form for it. We need reform in the prison system. That's the subject for another book of yours, right? But we are sensitive to that more so than the public realizes. And when it comes to sentencing, when it comes to compassionate releases, we consider the harshness that a person has been subjected to during his jail terms. So we need to deal, that's a whole different issue about, how do we deal with a failed prison system? How do we deal with a failed parole system? Every place you look, the United States is an embarrassment. And I can go on and on and on, but I'm not going to do it. I give you, thank you for letting me have the opportunity to express some of my thoughts. But the federal system, I think, has led the way. And the states have to follow up. And that's really what we're talking about. That's what I talk about in my book. That's what I lecture about. We have to really get it back together, be more sensitive, a little bit more humane as a society, and on and on and on and on it goes.
Yeah, yes.
Oh, sorry. Yeah, I'll be quick. I just, the question of excessive sentences, right, which is really what, and exceptionalism. I know I'm going to steal a question I think you want to put out later, but what can we all do? I worry about winning the battle, losing the war. We get a second look bill passed and nobody gets resentenced. And I say that to say that I'm looking at some of my friends. Where's Ted? He's out here somewhere, I think. There's an 18-year-old who got 50 to life. He's been in 34 years. Is he someone who has millions of accolades, masters? No. But when we're negotiating with the prosecutor and you just want to say, isn't enough enough? How much time must someone serve? And to me, so that what I'm saying is, what can people do? Yes, we're talking about legislators, but we've got to work hard on prosecutors. We've got to work hard on judges. Otherwise, we have a bill that's going to be opposed. I hear, Jenny, 5 people getting resentenced. So yes, we have to focus on the legislature, but at the same time, I don't have a lot of faith currently in the state judiciary or the elected district attorney.
I agree with you about the re-educating the prosecutors and the judges. That's a necessity.
Jenny?
Yeah, I'm gonna tell a horror story that sort of exemplifies this problem, and I really think it's on lawyers. I feel like we can say this in a law school to think really carefully about this exceptionalism problem. So there was a juvenile parole hearing maybe 6 months ago. We've only had like 10 of these, right? They don't happen very often, and there were 2 cases up. One guy, while he was in prison, was in a prison close to Chicago. He got his bachelor's degree from Northwestern University. He got out of prison onto work release because he got a Miller resentencing, and he had been accepted to Northwestern Law School. Like, I wasn't accepted to Northwestern Law School. This guy had done literally everything, and he got parole. It was not unanimous, but he was granted parole. He was already going to law school, right? He was already like living in the world. The guy who came up after him had lived a perfectly acceptable existence as one could live in prison. He was in a downstate facility. He had access to nothing. He still had like no disciplinary record. He had taken every correspondence course that he could possibly take. He had done what he could do, but he was not a Northwestern law graduate. Like, I don't know what to say. And he was denied. And until actually last month, basically everyone who came before our parole board, who was just like a regular human, which should be enough, has been denied. And so, I don't know, Steve and I have talked about this a fair bit, and David too, like, when we're taking these cases, I think it's really easy to just take the great cases, right? Because you want to get people out and it feels like a really efficient use of your time and you get pulled in and they're wonderful and whatever. But like, what we're setting the bar really high for the 99% of folks who also should come home and should not have to be PhD students in order to get relief.
Yep.
Thank you. Okay, so Steve alluded to it. I do want to put the question of what can the audience do on the table, and then we'll take a couple of questions, and I promise you all by 8 o'clock you'll be drinking and eating. But this is to drive towards action, right? So I think, Thomas, that there's something very concrete that people can do. I think there's a QR code. Can you tell the audience about that?
Good. Yes, and my comms director is here, so I'm gonna get a lot of points for this. So So my contract, she put together a QR code. It's a postcard. Everybody should have got one. Go in the back and scan that. That's gonna sign you up, to be involved. We also have some booklets on each of the bills. If you go to Communities Not Cages, website, we can actually sign you up, get you involved. One of the things that we know moves legislators is when their constituents. This is where the real power is. The reason why they don't move in certain things or certain bills, I've learned in my young years, as a lobbyist slash community organizer, is that if their constituents don't care, they don't care. So when they start getting these emails, when you get the phone calls, when you guys show up to the rallies, when you come to Albany with us, which by the way, we provide buses and I also pay for everybody's lunch. Well, I use CCA's checkbook, but get you to Albany, come be involved. This is how we get it done, and we can literally make it happen. Last year, and I'm gonna say this before I pass it, for Mother's Day, we went to Albany. We had like 312 people there, and that was a bump up from January. Because we had those 312 people there, we got a bump up in legislative support. A few more senators signed on, a couple more assembly members. I'm saying let's bring 600 people to Albany February 4th, right? And who knows what we can do with that. And that's not a large number, by the way. Cause we had 300, we know that could be done. So anyway, QR codes is here.
And what do they do with the QR code? Is it the point?
I'm new to this technology too. So you put your phone in front of it. It's gonna pop up on your screen, a button. You press that button, you can fill out everything from there. Did I do it right, comms director? Tanya? Okay.
Yeah, so December 11th, here in New York City and across the state, we have, can y'all hear me?
Yeah, turn it on.
Push the button.
December 11th, here in New York City and in 7 cities across the state, we have our statewide day of action called Defiant Hope. And so we have one here in Foley Square, so you should go to Communities Not Cages, NewYork.org. You can RSVP for that. February 4th, you can get on the bus. We're coming hundreds and hundreds of us from across the state. To be in Albany, we come with a band, we take over the halls, meet with legislators, we do a press conference, all of those types of things. So those are 2 ways to get involved right now. And then when you go to our website, you can contact your legislator. You can text them, you can call them, you can email them. We want to make as much noise as possible. Yeah. Also, I have stickers.
And so if people give you their information on that website or the QR code, then they will receive future emails and texts from you all about these upcoming actions. Is that right?
Yeah, on the Communities Not Cages, NewYork.org website, you can sign up there, right? And then on the way out, at the table on the way out, I'll have a sign up sheet for you too. So you can sign up and I'll make sure that you get all the info.
Okay, great. Thank you. Thank you. And what else can folks do?
I'm happy to be a part of my organization, newly established organization, the Pillars of Promise. We're part of the coalition of CCA, and we're happy to be a part of them. And there's going to be statewide rallies throughout 6 locations in New York, and I'm going to be I'm going to help organize the rally in Westchester, in the Ossining area, and my other co-founder Terrell Overton, he's going to be speaking and helping organize a rally in Albany. So there's going to be statewide rallies on December 11th in about 6 locations in New York, and that people can access depending on where they reside at. We would love your support, and of course, the rally in Albany on February 4th. We would like to have significant numbers attend that rally as well.
Steve, anything else? Did we leave anything off?
No, I don't think so.
Okay.
From the legislative piece,
Okay.
I just wanted, if how do we go about changing hearts and minds? It's the rallies, they all matter, but at some point, people who have access to op-eds, people who have access to the media, people who have that kind of access, just has to spread the word. That's all.
Thank you. We're gonna take a couple questions. Yes. Just turn your mic on and go for it.
Okay. Hi, I hope everybody can hear me. My name is Felicia Keen. I'm an intern with the Salazar office, and my internship involved reading letters from incarcerated individuals from prisons like Attica, Auburn, Five Points, Sing Sing, Sullivan. And, I really appreciate the panelists' thoughts about redeeming yourself in prison, but, in most of the letters I hear about people getting not necessarily worse, but physically and mentally deteriorating in prison. I've read letters from people who have been assaulted by CO staff. I've read letters from people who have resulted to self-harm because of violations of the HALT Act. So this question is open to all panelists, but maybe it will be of interest to the judge and the formerly incarcerated people. How would we go about getting people who have been physically and mentally deteriorating in prison a second chance? Like, how do we get people who haven't even been offered access to programs get a second chance? You know, especially people who have been, you know, I don't want to say disciplined, but just abused by doc staff.
So you ask a very good question. I've spoken to, Senator Salas's people. You may know that. And it really, I was just so upset by the fact that it's so difficult to pass something that seems so basic and so humane and decent and provides a vehicle to have access to make these arguments. So we get these applications, and many I have, from people who have dementia. They're old people. They just don't even know whether they're alive anymore, and they're living in jail. They want to die at home. There's a humane dynamic to all of this, but there's no magic formula to it. But you need a vehicle to have access to the judicial system. I can't speak for all the 700 district court judges, but I do think over the last few years we're making some incremental changes. That because this statute was enacted, the judges have to think about. They have to have a second chance now to think about what they've done in the past. So it's a collective process here. You got to start by getting that damn legislation passed. And I think I'd make a good community activist if I can do it all over again. Right?
Yes, sir.
Yes. This is William Steele. I have a question for the Honorable Frederick Block.
Oh boy.
You mentioned specifically that you had at one point sentenced an individual to 3 consecutive terms of life in prison, 5 consecutive terms in life in prison.
Yep.
In that experience, okay, you rectified that matter, but in that experience, how did you feel as a judge? Did the mitigating factors of that case warrant that sentence at the time from your judgmentship of that individual?
Look, I did that when I was my second year on the bench, and it wasn't unlawful. The laws have changed since then, and I applied the law at that time. Mandatory lifetime sentences for 3 strikes are outlawed. That doesn't exist anymore. The laws change. We have to be aware of that. It's not opening up the prison doors to everybody, but there are worthy situations which you have to be sensitized to. The judges can't stay like stones forever. Nobody should. So, in answer to your specific question, I sentenced that person to 5 lifetime prison sentences for life, and I let him out. He's a free man. One of the things I really feel good about the little lives that we have to live is that I'm in a position where I really can make a difference in a human being's life. And it gives me great pleasure to be able to do this, and I hope I can stay on a little longer because it gave me the opportunity to do the right thing for Walter Johnson. So, I commend that to you. I mean, it's really a template for what we have to do. I think my colleagues are becoming sensitized to it. One of the things that I do is I talk to my colleagues about the fact that, look, you've got to really be a little more open-minded. You got to be a little more humane. This is a vehicle to do the right thing, and we're in the business of doing the right thing. It's working incrementally. There's no magic pill. There's no magic formula. It's a process, like most of the things we have to deal with in law. But to be sensitive to this, we're speaking to the audience right here. We got to get this message out to all the other people, the people, upstate, the Republicans out there. The concept of redemption, it is a biblical concept. I think it's great. I try to do that also. And I think you have to talk it up, and you have to do more what Senator Salazar is doing. And we got to isolate those people who are holding up progress and politically deal with them, I think. So, I mean, I don't know if that answers your question. I feel pretty good as a human being who has had the opportunity to make a difference in some people's lives. And it brings tears to my eyes as I talk to you right now. But I don't know whether I'm representative of the general population.
Thank you. Yes, sir.
Yeah, so I wanted to ask this when you were talking about how institutional records are evaluated in cases like this, and how some CEOs will give out tickets like candy.
Yeah.
Some of my coworkers work on devious GA motions for a living, and your institutional record, including your disciplinary history, are very much taken into account. Some of my coworkers specialize in parole applications, and your disciplinary history is very much taken into account. And the thing is, there are no standards on disciplinary hearings, right? Like the standards of evidence that they need to hit don't even they're like absolutely ridiculous, and you don't even have to be like 50% chance that they're true, and then that not only could lead to you being in solitary confinement, residential rehabilitation unit for like a year. Not only that, but then it can also affect how you get out. And then also, even if the CO lied about it, there's very little ability to hold them accountable because they all close ranks and they lie and have an incredibly strong union. So similarly to this question that comes up for the NYPD a lot, what I'd like to ask is how important, and this can go to any panelist, do you think it is that we bust the corrections officers union, and how do we make that happen?
Okay, so just so the panelists know, there's about 20 people that want to speak. We're only have time for 1 or 2 more questions. So I'm just going to ask one person to respond to any particular question. Anybody who wants to take on this question of the whether we should challenge the corrections officers union, and if so, how?
Yeah, I support unions. I support unions, and we should bust them up. I don't understand how they have that much power. Like, people so scared of them. When you have the power, you have the voting power. So the answer short is yes. You need to find a way to crack that. But I love unions, by the way.
Yes, sir.
Trying to get it to speak. Oh. Thank you.
Yes,
My name is Stanley Bellamy. I'm the New York City community organizer for RAP, Release Aging People in Prison. Also, member of the Clemency Collective. Now I have 2 things, and I'm also one of the individuals that was sentenced to an excessive sentence. I was sentenced to 62 and a half years to life in prison. And if it wasn't for Steve, Aaron, Nicole, and my hero, Bahar saying, I was taken sitting in prison serving 24 more years. And I say that when we talk, and I don't disagree with anything that was said on that stage. I support the Second Look Act. My organization also sponsors the Elder Bill and the Fair and Timely Parole Bill. But when we talk about excessive sentence, those mechanisms that we're talking about are back-end approaches. If we really want to address excessive sentences, we need to look at, in New York State, the consecutive sentence. How they give out consecutive. I had 62 to life because I had 4 sentences, consecutive. In 1979, the New York State courts decided that under Penal Law 70.25, they was going to determine how you could receive consecutive sentences. And they came up with this term, separate and distinct acts. And so they mean every act you commit, you can be sentenced on separate and distinct acts. Before, it was just a single transaction, a single whatever. If we really want to address a consecutive sentence, we need to look at that front end and addressing the consecutive sentences. And that's how you would change at least the excessive sentence. But those other things, the mechanism that we apply to the back end, and that's needed.
Thank you.
Hey, Mr. Forman, just real quick on that.
Yeah.
So our Community Not Cases campaign does address that. One of the remedies that we come up with is called the Marvin Mayfield Act, and that eliminates mandatory minimums. And so what that will do is, here's the craziest thing. I'm quite sure the judge will agree with this. The most neutral person in a criminal procedure is who?
The judge.
The judge. But our sentencing structure and laws tie the judge's hands, so they have to be stuck or locked into certain things that my brother just shared and stuff like that. So Marvin Mayfield Act is part of the Community Not Cases campaign, and this will eliminate mandatory minimums, put the power back into the judge's hand and out of the prosecutor's hands, so that we can sentence people more appropriate, if at all.
20% of our cases are mandatory minimums, and Congress has sentenced these people, not the judge, right? I agree with you 1,000%. Under the First Step Act, by the way, you don't have to be rigidly adhered to mandatory minimums. You can get under the mandatory minimums.
Mhm.
Hi, thanks. This was amazing. My name is Marta Nelson. I'm from the Vera Institute of Justice. agree with everything you said. I was just in Albany yesterday, meeting with, people in the governor's office, people in the assembly, and I just have a couple of notes to your question, Judge. Why is it taking so hard to get this done? People have a narrative right now that people are concerned about safety, right? So you've had answers to all the questions, but just, can you hear me? Oh, but as you're already doing, you have to be able to address why this is safe for communities. You've got the answers, but just know that there's an interpretation that this last election means that they can't do anything that would upset safety. The other note is that this has to seem both urgent and common sense. Everything I've heard today, I'm like, yeah, exactly. Moral issue, people, the urgency is important because they're just going to kick this can down the road as much as they can. So in your messaging, the urgency and the common sense, everybody can change. We've all seen it in our lives. We all know people who have changed. It's a moral issue, as Steve had said. Finally, we just did some polling about how important, how popular these issues are, and they are popular. New Yorkers support second look. 68% of New Yorkers say it's a great idea. 74% say the Earned Time Act, which is another bill that CNC is doing, is a great idea. So we just have to show legislators don't know what New Yorkers want. So we have to tell them what New Yorkers want, as you're all doing.
They don't trust the judges.
Doesn't second look make prisons safer? The opportunity for inmates to know that they have this, it's not just redemption, but it's redemption which has the possibility of being restored to society. And doesn't that make these, isn't that the argument to make to people? I'm a Supreme Court justice in New York State. I actually sentence people. But isn't that the argument to make that you're going to create a mechanism that's going to fundamentally alter the way prisoners interact with the system, because it's not just redemption, it's redemption with purpose.
Yes.
And the purpose is the interest in ultimately becoming free again.
And I also think you're gonna further aid the transformation of our communities and societies as a whole, because most of the individuals who are deserving of second look are going to return back to society and be positive contributors to their communities. So the more you allow these individuals to gain relief, the more you actually help our communities. And I think that's
a circle.
exactly, and that's why I think it's important that we educate the public on the societal benefit of second look legislation.
Thank you. So when I started, I asked everybody who is aware of the issue of excessive sentencing and who is working on it or planning on working on it. So now I just want to ask the second question. Who is working on addressing this issue or planning on working on addressing this issue in the months and year to come? Can I see a show of hands? Okay, thank you very much. Panel. We